discuss about the latest case law on the on the GST refund, that is SICPA India Private Limited. So in this case law, the Sikkim High Court ruled in the favor of the SICPA, allowing the refund of 4.37 crores of the ITC post business closure. Now the thing arises whether section 54, now let me brief you about what is section 54. Section 54 is about the refund, and under subsection 1 provides, and the first proviso of section 54 subsection 1 provides for the refund of the cash balance. Electronic cash balance ledger balance can be refunded in any cases, right? So there is a doctrine of unjust enrichment which is not tested. Generally, the refund provisions are included in the law based on the doctrine of unjust enrichment. Now, question arises: what is unjust enrichment? Unjust enrichment speaks that nobody can expense or can enrich himself at the expense of others. So, in the similar manner, whether the department can withhold the taxes without the authority of law. This is the situation arises, this is the thing, this is the testing that is to be inbuilt in the law. But when specifically when the electronic cash ledger balance is already covered or can be allowed as a refund at any time based on the interpretation of subsection 54 subsection 1 first proviso, the condition of 2 year doesn't apply on it. Now the issue arises with respect to the ITC, with respect to the electronic credit balance, whether refund can be allowed. Section 49 subsection 6 says that you can take the refund, but so in accordance with the provision of section 54. But section 54 doesn't allow, or section 54 subsection 1 is very much clear about the electronic cash ledger, but it is not clear with respect to the electronic credit ledger. If you read section 54 subsection 3, the ITC accumulated credit balance is dealt by the section 54 subsection 3. So in the present case, the department rejected that under section 54 subsection 3 only two situations are covered, that is ITC refund, that is ITC refund is only eligible for the zero rated supply. That means section 16 of IGST Act explains the zero rated supply as the supply which is for the either for the export or for the sales client for their authorized operation. And second one is the inverted duty tax structure. Now question arises, what is inverted duty tax structure? That inverted duty tax structure is where the input is taxable at 18% or higher than the output of which is produced as 5%, right? So in such scenario, the differential is accumulated and resultant the inverted duty tax structure is allowed as a refund. The first proviso says that no refund can be allowed except in these two situations. That is the first proviso, not the main section of section 54 subsection 3. But the authority denied the refund based on this, the first proviso. Although in the first proviso, the further proviso also does not restrict the refund in the cases of business closure. So अब now question arises whether a person right can be taken away if the procedure is missing in the law, or the law doesn't specify the situation of refund in which the right was arise. So the petitioner, that is SICPA, filed a mandamus. Okay, so these are the writs. Writs are filed. There are 5 kind of a writ: mandamus, certiorari, and the habeas corpus. But in that case, it is the mandamus. Mandamus is used to authorize the higher court to rule or to enforce the action for the lower authority. So in the similar manner, this was filed by the company. Now section 49 subsection 6, that was a right in which the actionable cause was arise. The refund can be made including the refund processing via PMT 03. This is the rule which speaks that. But the thing is, Now here comes into play the constitutional right. The right was a right in section 49 subsection 6, but it is only a specific scenario which is covered in section 54 subsection 3 with respect to the ITC. Now the thing is, when the law is silent, who will what will prevail? Now there is a article is in Constitution of India which speaks that nobody shall be deprived of his right of property, and property not only included the land or the asset, it also includes the ITC. That is also a statutory right which is provided in the law and also not denied. So in the similar manner, when the doctrine of unjust enrichment is applied to the department, then by way of Article 265, that no tax shall be collected except by the save as authority by the law. And now when a law itself speaks that in one section, that is section 49 subsection 6, that explicitly permit of electronic right ledger balance without a limitation condition, then their department doesn't have any right. In the precedent of in the excise law, there was also a Senvet credit rules in which this kind of a situation was arise where on the closure of business the refund was not allowed. Then the rule 21A was interpreted with the precedent of the law that in such situation the refund shall be allowed, and based on this perspective and by invoking Article 265 read with Article 300A, then the refund was granted to the assessee. Now the risk associated with this case law, that if this case law was implemented, there could be a case that might lead to a fake firm who is applying for the GST refund, and sometimes the accumulation of the credit was ambiguous in this nature. There is nowhere in the case law which is stated how the ITC was accumulated. So there is a risk, and it is pending whether department will file the appeal or not. As per the recent circular, then the department has a right to file the case or defend the case by applying in the Supreme Court. Now let's see what would be the future course of action in this scenario. But yes, there are the risks associated with this scenario, but although it is in favor of the taxpayer. Thank you. This is all about the SICPA case.